Right, thank you, Petra. Thank you, CMS, for inviting me to speak on the topic of two-stage tendering. A buzzwords, actually, since RWS published its white paper last summer to announce this new method of procuring infrastructure projects as a possible solution to solve some of the problems we are experiencing right now in the Netherlands. This is what I would like to do this afternoon. What I would like to do is to first explain to you what is actually the problem we're trying to solve in the Netherlands right now. And when I've done that, that gives me some opportunity to explain to you what I think two-stage tendering is probably about when I read the white paper of RWS. And that enables me to make some kind of an evaluation of the solution that is being presented and to see how it can be compared with other solutions that are currently on the table. So, what is the problem that the Dutch are actually trying to solve as we speak? That story begins with the practice of traditional tendering that existed for the last 2 centuries in our country. And it still exists to a certain extent. But since the 90s, something has changed. I get to that later on. But what you see here is the typical example of traditional tendering, which I think is also familiar to many other countries, where the employer first decides to enter into a contract with the engineer, and then the engineer starts working on the design, starting by a conceptual design, a preliminary design, the basic design. It becomes more detailed in the detailed design, and then in the end there is this final design. And then the employer takes up the design prepared by the engineer, gives it to the contractor and says, please construct the work according to the design that was prepared by the engineer. What the engineer does in this design stage is that he prepares the design based on the requirements of the employer, of course. But what he also does is this, and I think this is perhaps the most important slide in my entire presentation. Because this, ladies and gentlemen, is very important. This is where it is all happening. Crucial choices having a huge impact on the project, they will be made at this very stage. So choices regarding how to design the construction project have obviously taken into account all these very important external project risks, particularly in the Netherlands, where half of the country is built in the marshes, where we really have to have a close look at the subsoil conditions, of course. So this is what the engineer has to do, and it's an important part of the project. Now, when he has done that, the employer hands over to the contractor the design completely prepared by the engineer. And what the employer usually also does is that he hands over all kind of data to the contractor, explaining what conditions the contractor will probably may expect and encounter when he starts working on the construction project. What then happens is that, and this is also a very important slide, I think, is that the contractor offers a fixed price. What he says is, I will construct the work based on your design for a fixed price. And if the employer then accepts the contractor's offer, I have to say, if he accepts the contractor's offer, a contract is concluded and the contractor will then carry out the project according, again, on the basis of the design prepared by the engineer. Now, this has been the traditional model being used in the Netherlands for two centuries. What were and still are for some part, the problems inherent in the traditional model. The first problem is, of course, that the engineer is not capable of predicting for 100% how these external projects risks will interact with the design of the engineer. So that leads to the situation that design choices are not always properly attuned to the external project risks due to a misinterpretation of these risks by the engineer. For instance, foundations of the building or structure are designed not properly, are not attuned properly to the existing subsoil conditions. And many of you will probably understand the consequences the employer will then have to face during the construction stage of the project. He will be confronted with claims by the contractor. Will probably have to issue change orders. Will have to pay for all this, and more importantly, it will be very difficult, at least in our legal system, to recover all these costs from the engineer because of very severe contract liability exclusions in the contracts being entered into between the employer and the engineer. Traditional tendering also showed another problem, and that is the problem of offering fixed prices in direct competition. That is one of the main problems as well, and we know now what the risk of this can be if we look at this second problem in combination with the first problem. Fixed price tendering, particularly when the market is low, may lead to irresponsible bidding, and then you run the risk of exploitation of design failures during the construction stage by the contractor. Traditional tendering also has some additional problems. The ordinary contract law framework doesn't really help the parties to collaborate in facing the above problems in a rational manner. So that's also a problem inherent in traditional tendering, and particularly for the traditional situation, obviously the problem of the employer having to fight a battle at two fronts, both at the front of the engineer as well as at the front of the contractor. Now, in the 90s, something changed. We moved from traditional towards integrated tendering. Employers started to experiment with procuring construction projects on the basis of design and construct contract. So one contract with one party that was made responsible for both the design as well as construction. And one of the early adopters of this method of procuring projects was Rijkswaterstaat. And here you see what's happening. The employer is still making some very basic design choices, of course, but then he hands over the design task to the contractor and instructs the contractor to do the rest of the design work and then construct the project according to the contractor's design. Now, what caused this transition from traditional tendering to integrated tendering? The most important reason is that everybody thought that this would make projects, we could realize project faster, it could be cheaper, and we would have less interface problems on the interface between design and construct. That was actually the main reason why we did this. And an additional advantage could be that the employer was no longer required to fight the battle at two fronts. There was also a perceived advantage in the sense that it was thought that, well, if we impose the design duty upon the contractor, the employer will no longer be responsible in case of all these design failures because it's the contractor who will prepare the design. Well, it's questionable whether that is true, It's not true in the Netherlands. If you look at the standard form we developed at the end of the 90s, the Uniform Administrative Conditions for Integrated Projects, where we took a more in between position when it comes to who does actually the design in such an integrated project. Because in any project, even in an integrated project, an employer will always make design choices, of course, to some extent. The standard model I just showed you imposes the duty upon the employer to at least make the conceptual design, and it's optional for him to also prepare the preliminary design and the basic design under the Dutch standard form contract. But this is more likely what will happen in practice, in the sense that the employer will stick to the conceptual design and then will ask the contractor to make an offer for preparing all the subsequent design stages and ending with the construction stage. So that is what the contract will have to offer. And what happens then, of course, is that the contract will become in the same position as the engineer was under the traditional model, because now it is the contractor who must take into account, when bidding for the project, all these external project risks. And that means that it is the contractor who has to collect all kinds of data on these external project risks. And he will have to do so for a large part during the tendering stage, so in preparation of his bid. That doesn't alter the fact that the employer will also supply data prior to tender in order to enable the contractor to actually prepare his bid, or not, as you can see on the slide, because that is one of the issues in the Netherlands, that there is no duty imposed upon the employer to actually supply these data, because it's a pre-contractual duty, of course, which is difficult to deal with in a standard form of a contract model. What you could deal with is regulate the consequences of situations where employers did not provide any information prior to conclusion of the contract. You could deal with that, obviously, in the contract itself. But this is one of the big issues in the Netherlands, the supply of data prior to tender by the employer. So what are now the problems occurred in integrated tendering? Well, like the engineer in the traditional tendering model, the contractor cannot control the external project risk for 100% either. That problem is actually similar, as we've seen in the traditional model. So the problem that occurs is similar as in that model, albeit that the problem is now no longer on the table of the employer via his engineer. No, it's on the table, it's on the plate of the contractor. Another problem we've seen in the traditional model is now returning also in the integrated model, because again we see that the contractor has to offer the carrying out of the design and the construct stage for a fixed price, and he has to offer that fixed price in direct competition. So again, the problem is on the table, where particularly in certain market conditions, irresponsible low prices are being offered, and that's particularly a problem in combination with the first problem, the problem of not being able to make a right estimation of all these external project risks. There's also a new problem prior to the conclusion of the contract, and that's this. Prior to the conclusion of the contract, the employer doesn't know yet what design choices the contractor will make in the course of the project. And once these choices are made, employers are sometimes surprised, and not always in a positive manner. And that leads to situations where the employer will try to move the contractor to reconsider his design choices. And then you get these discussions in the lock-in situation of a contract. Is this a non-conformity, or is this actually a change order? That's also a big issue in the Netherlands right now. So, what conclusions can be drawn from this problem analysis, both as regards to traditional tendering as well as integrated tendering? And then I agree with one of the people in the audience. Yes, there is a fundamental problem. There is a fundamental problem. Design choices, they are based on assumptions that are not always 100% correct. Now, and to all the people working in construction, this is not something to be ashamed of. It is inherent in construction. Predicting 100% certainty at the time of conclusion is an illusion. It's an exception to the rule, and the rule is you cannot predict that 100% certainty. So the question then is, how are we going to deal with this problem? Because we need a solution to control the consequences of the risk. And we need it very quickly, and we need it very badly. So, what else is an observation that can be made? What we have to bear in mind is that whatever the solution we opt for, whatever the solution we want to try, it's always a matter of money. Any solution we want to adopt to solve the problem is a solution that will cost us money. That being the case, we have to think of the right stage of the project where we want to incur these costs. Do you want to pay at the end of the project to solve it at the end, actually to take away the consequences of the risks? Or do you want to invest the money at the beginning of the project to lower the chance of a risk from occurring? That is the key question, I think. Now, that brings me to the possible solution of the problem. And then the question is this two-stage tendering model, is it a solution? Before we can answer that question, it's first necessary to see what is actually two-stage tendering. And what is two-stage tendering, particularly according to RWS? I only have access to the white paper, the document in which the solution is being proposed. And if I look at the pages where the solution is being described, and I've tried to translate in English the relevant passages, then you can see what is actually what the meaning of two-stage tendering is. And the meaning is that what the employer wants to do is to commission both the design and the construct to one party, being the contractor, and that is the same as is the case, of course, in the ordinary integrated tendering of projects. But what is different now is that what we would like to achieve with this process is to cut the design and construct into two stages, allowing the employer to reconsider the construction stage at that cut. And what I also read in these lines that I've taken from the report is that each stage requires a separate contract. So the picture would look as follows, where we have an employer who wants to work with one and the same contractor in two stages, and for every stage a separate contract is needed. And one stage deals with the preparation of the design, and the other stage deals with the construction phase. That is how I read the report. Now, if we want to evaluate this approach, this two-stage tendering approach, we need some criteria to test it. So what is good on the model? What could be improved? And I think we could think of many criteria, of course, but the most important I could think of in preparing this talk for you today is that a solution will be a good solution if it does four things. It has to contribute to early contractor involvement. It would be nice if the solution would help us to pay the extra at the beginning and not at the end. We want to pay for prevention and not for failure. It would also be very nice if the solution would stimulate cooperation instead of stimulate adversarial relationships. And last but certainly not least, the solution obviously has to be in conformity with public procurement regulation, being in the Netherlands the Dutch Public Procurement Act. So the question then is, does two-stage tendering meet these criteria? I ticked the box at several places, as you can see. I think the two-stage tendering model, as envisaged by RWS, has a good score on some of the evaluation criteria. Contribution to early contractor involvement. For large part, the money that we need for the solution is paid at the beginning. Not entirely, but that's not different from traditional tendering. And I think it's also a model that will stimulate cooperation in the sense that people will particularly be focused on cooperation at the design stage, and that could have a positive effect on the construction stage. But I also see a possible risk, and that is the test on the criterion of public procurement regulation. As I read the RWS white paper, only one contract is brought to the market via direct competition, and that is the design contract. And then a construction contract is later on entered into with the winner of the tendering procedure, apparently without any direct competition. And even if my understanding of the sequence of events is incorrect, I still see another possible risk. Even if design and construct contracts are being put out to tender at the same time, it doesn't alter the fact that only the design contract will be concluded at first instance, and that the construction contract conclusion depends on future agreement between the parties. The main risk I see is that in this model, parties need to negotiate the latter agreement, the construction contract agreement, and that they have to do so outside the framework of any direct competition. And that is, I think, the major risk from a public procurement perspective. Again, if my interpretation of the model on the basis of the report is correct. When I read the RWS paper last summer, it was a bit like taking a stroll down memory lane, because the more I read about it, the more I recognized, and this always happens to law professors when they read all kinds of solutions. They think, well, I've written already once this solution, so what's happening here? But that's exactly the feeling I got when I read the model, because I was invited 20 years ago to write a piece on this very same topic for the Dutch Society of Construction Law. And I recognize many things of the two-tendering stage approach in that model of 20 years ago. As a matter of fact, I think it's the reason why Marjan Volek and I once met 20 years ago, because it was exactly about this model that we discussed 20 years ago. What is that model? How does it look like? Well, it's again, it's 2 stages, and yes, it's with one contractor, but it is also one contract. So that's the difference with the model as proposed by RWS, where the employer is actually entering into 2 separate contracts with the same contractor. Here you can see that both the design phase as well as the construction phase are being covered by one and the same contract. Now, I had to read the research of 20 years ago again to understand the model again, what was actually the meaning of it. But in short, this is what is happening. So it's one contract involving both design and construct, and that contract is being put out to tender in competition. The contractor can then make an offer, again, in direct competition, and what his offer has to deal with is that he has to give a global description of his design solution. So what I am going to construct later on has to be based on a global description of that design solution. He also has to offer fixed prices for work and materials as envisaged in the design solution, make an offer for profit, he wants to earn overhead, and very important, he has to make an estimation of the costs involved in the construction stage as a whole, and he has to offer these estimation of costs with a margin of reliability. That is what he has to offer. And many other contractors will have to offer that in the tendering phase. And the comparison of the tenders will be made on that basis to see who is the winner of the design and construct contract. And what happens then is that a contract is being concluded with the winner, and that contract deals with both the design and the construct stage. That contract holds detailed arrangements, of course, for all kinds of risks that might occur during the project, particularly in the course of the design stage. At the end of the design stage, what's important, what cannot happen is that parties start negotiations on the price for the construction stage. That is not allowed from a public procurement law perspective. So the costs related to the construction stage have to be determined on the basis of a transparent cost estimation with regard to the contractor's offer at the very beginning. What also can happen is that during this design stage, all kinds of risks may pop up, as they will always also pop up in the traditional tendering model, where they pop up on the desk of the engineer. They pop up, these risks, and that means we have to deal with these risks when they occur in accordance with the arrangements made in the tender documents in advance. Now, dealing with these risks could mean that the margin of reliability that was offered by the contractor is exceeded, and that in that case, and that also resembles this 2-stage approach by the RWS. In that case, the employer may decide to cancel the contract at the cut between design and construct. This is a bit of a difficult question for me. Does the proposal meet the evaluation criteria? I would say yes, of course they do. Why would I disagree with that? But I think I have to add that this model was discussed and tested all around 20 years ago by many people, and we particularly had a close look at the most important criteria where we saw the biggest risk, which was obviously, again, the public procurement regulation. And we think that on that criteria too, I still think that is true, that the model is, I think, more safer model from a public procurement law perspective than the model, as I understand it now, from the white paper of RWS. And what is particularly relevant in this model is that negotiations about the price at the end of the design stage are strictly forbidden. That is the biggest risk from the perspective of public procurement law. And if that risk could tackled in the same way in the RWS model, then that we would be a step further, I think. There are also some additional advantages in the sense that we need sufficient pressure on price. We think it's present in the model. Tender costs may be lower. The employer will know in advance what his maximum risk will be. A bit similar to the traditional tendering, of course, where the contractor has to do a bid on the basis of the design of the engineer. And in the perhaps theoretical but nevertheless important event that the employer decides to cancel the contract because of the margin of reliability is exceeded, there are ample opportunities for the employer to continue the procurement, the project, but then in a different way, as you can see on the slide. There are many solutions on the table. I only discussed a few. I will now conclude with some final comments on two other solutions being offered. One deals with this model. I couldn't find a better word in English for bow team than construction team. But this is a model that actually exists already in the Netherlands since the 50s of the previous century. It's a very old model. It was used to reconstruct Rotterdam after the Second World War. And this model is actually a model where the employer commissions, again, the design and the construct, the two parties. So it's not a variant of the two-stage tendering. It's a variant of the traditional tendering model. And the variant is that the employer and the contractor, they do not only enter into the ordinary construction contract, they also enter into a pre-contract, imposing a duty upon the contractor to advise the engineer in the design phase. And once that advice is finished, the design is finished, the contractor gets an exclusive right to offer for the construction contract. If you put this model against the evaluation criteria, it gets the same score as the two-stage tendering model of RWS gets on that scale. And again, it's particularly, I think, the risk is in the application of public procurement regulation. A final solution is not in changing the model, it's in changing the contract. Because one of the discussions we have over the years is the standard form of contract of the Dutch, does it adequately deal with the fundamental problem that we have now discovered in the procurement of integrated projects? And is it perhaps possible to deal with the problem by changing the contract conditions? I was involved in the 90s in the original draft of the standard form. I'm also involved in the current redrafting of the revision process. I cannot say much about what we're actually doing behind closed doors, but let me tell you that a reconsideration of provisions in the contract dealing with these cases where the design and construct contractor has had an incorrect perception of reality, reconsideration of provisions dealing with that problem are on the table as we speak. Because we have discovered that the contract particularly is harsh in the event that the contractor made a miscalculation, but he made that miscalculation in the tendering stage in a case where the employer did not provide any, or at least not sufficient, data prior to tender. And the solution that is on the table for that particular situation, it's not being taken the decision yet, let me be clear about that, but what we're talking about is in such situations, wouldn't it be a better idea to come towards the contractor and to see if we can pay him, if he can be paid extra for a risk that was reasonably not to be discovered for him, having regard to all the circumstances of the case, including the circumstance that he did not have sufficient information and information wasn't provided to him either. This could be a solution, but if you look at the criteria to evaluate the solution, then you see that it scores okay on the early contractor involvement. And yes, it's in conformity with public procurement regulation, but it is also a solution where you pay at the end. And you do not pay at the beginning. You just let the problem evolve, occur in the construction stage, and then you take a contract clause and you say, well, this entitles you to extra payment, so let's give you the payment. That it's investing the money at the end. And that being the case, it's also still a model that is based on the classic paradigm of contracts, not stimulating actually cooperation, but more stimulating adversarial relationships. I mean, I love the contract, I've put a lot of work in it, but nevertheless, if you put it honestly against the test criteria, it's not the best solution that's on the table right now. Right, that's it. Thank you very much for your attention.